Welcome back to Winning Isn't Easy. Parkinson's disease secondary to solvent exposure and your ERISA disability insurance claim. Did you know that TCE is an organic solvent that's used as a cleaning agent? It's used for removing oils, greases, and contaminants in machinery and aircraft. There is a strong association between the use of an exposure to TCE and the development of Parkinson's disease. So what is the nature of Parkinson's disease? PD is a chronic degenerative disorder of the central nervous system that impacts both the motor system and the non-motor system. Early symptoms can include tremors, rigidity, slowness of movement, difficulty with walking. And these symptoms will normally emerge and develop slowly. As the disease worsens, however, you may have non-motor symptoms that will include things with cognitive behavior, sleeping, or sensory issues. Now, there is generally a long period of time from the occupational exposure to the organic solvent, like TCE, and the development of PD. How does this impact your disability insurance claim? Well, you may have purchased your disability insurance policy or plan through your employer, or maybe purchased your own individual disability policy. But before you stop work and apply for benefits, it's crucial that you do two things. First, you got to obtain a copy of that insurance policy or plan and read it cover to cover. What's the definition of disability? What's the definition of your occupation? What's the definition of, is there a subjective medical condition limitation? Is there a mental nervous? Understand the four corners, if you will, of that policy or plan so you know what it is you have to prove. But next, you've got to look at your medical records, because often disability benefits are denied because the medical records don't develop the symptoms, the progression of the symptoms, the diagnosis, how those symptoms make it difficult, if not impossible, for you to perform your own occupation or any occupation. Now, this is where the policy definition is really important. Disability can be defined as the inability to perform your own occupation or the inability to perform any occupation. Normally, what will happen is benefits will be paid for 2 years for own occupation benefits. And then the definition is going to change to an inability to perform any occupation. Now, that's really crucial because you need to understand that the definition of occupation is not ensuring your ability to do your job, but not only your ability to do your own occupation and to do any occupation. Both these definitions, own occupation and any occupation definitions, are really crucial to understand. Sometimes the own occupation definition will say, well, it's not how you performed your duties for your employer or in your local economy or even your national economy. It was how this job is described in the Dictionary of Occupational Titles, which has not been updated since 1990. So you've got to work your way backwards from that DOT job description to understand what that definition is so that you and your doctor can document what it is you can't do about the material and substantial duties of your occupation as how that term is defined. Now, that has the same impact if you've got a residual disability provision in your policy. In other words, you may be able to work, but you have to have a certain loss of earnings and a certain loss of earnings as a result of the loss of certain functions of your occupation. Again, you need to understand this. Remember, of course, that the definition is going to change generally after 2 years to an inability to do any occupation. And once again, you need to understand what that means, because normally you will see language that says an inability to do any occupation by virtue of your education, training, and experience. You're not talking about age. And what's important here is that the disability carrier is going to do an analysis of your restrictions and limitations as documented by your physician and by their peer-reviewed doctors to determine both physically and cognitively what it is you can do. And they're going to take that and try to fit it into a box to say, oh, well, by the way, you have certain skills that you have learned that you could take to other occupations. That's called a transferable skills analysis. And they will use that to try to reduce the amount to determine whether you're entitled to your own occupation benefits. Now, the question I get often is, Can I appeal a wrongful denial or termination of my benefits? And the answer to that is yes. But what's more important here is that we not have a denial or termination. You want to be working, in my view, closely with an ERISA disability attorney and filing your application. And if the claim gets denied or benefits terminated, that you understand that you do have the rights to file an appeal. Disability policies or plans have different timelines and requirements. But generally, the carrier or plan has to send you a letter detailing the reasons why the claim has been denied and the information that you need to submit about for the appeal. The appeal is the trial of your case, and you can lose that appeal by not treating it as such. So simply writing a letter that says, I'm appealing isn't going to cut it. You definitely need to have the services of an experienced ERISA disability attorney to look at the policy, look at the claims file, look at your medical records, develop the necessary medical and vocational evidence, getting a statement from you, getting a statement from the doctor, maybe getting an FCE, maybe getting some neuropsychological testing, and then writing a letter addressing the ERISA law as it applies in your particular circuit, explaining in detail why the termination or denial is incorrect. My appeal letters, by the way, are 25 to 65 pages long. And as I've said, simply writing a letter saying this is an appeal won't cut it. Simply sending in new medical records won't cut it. It has to be an organized, cogent explanation as to why that disability carrier's denial or termination is wrong. Got it? Let's take a break.